Hi, my name is Pouyan Darian. I'm the principal attorney here at Darian Immigration Law, where I focus my practice primarily on helping families apply for adjustment of status, which is a green card, as well as citizenship and immigration court proceedings where people are being deported. Hopefully you don't find yourself in that last category. Today, I'm going to discuss a common question that I receive. I've done hundreds of these cases over the last few years, and during that time, I would say on average, 3 times a week, I receive this question. Where is my work permit? When is my green card gonna come? And I review the paperwork, and I see that these families have only filed a single form, Form I-130, Petition for an Alien Relative. And unfortunately, I have to explain to them, look, you failed to file all the additional other forms that you needed to. You could have possibly done all of this in one single step and saved yourself more than a year of processing time. But since you're doing it in 2 steps, we're not eligible for the employment authorization or the green card yet. Now that might sound really confusing, so I'm gonna break it down into 3 situations. The first is the most common one that I see. That's where a U.S. citizen spouse petitions for their immigrant spouse by only filing Form I-130. That person or that couple should have filed the Form I-130 along with all of the other forms simultaneously. The form for the green card, the form for the work permit, the form for permission to travel, affidavit of support, and any supplemental documents should have all been filed in a single step, in a single package, all mailed out at once if you're a U.S. citizen petitioning for an immigrant relative spouse. That's the first category. Now, the client comes in, they show me, a U.S. citizen and their spouse come in, and they show me that they filed Form I-130. And they ask me, when is the green card coming? When is the work permit coming? And I have to respond to them, unfortunately, you have never filed for those applications yet. You've only filed Form I-130, which is fine, but that is going to add another 8 to 12 months processing time to the situation. So that was a mistake. And what can we do now? The I-130 is pending. It's very simple. We would take the I-130 receipt notice, attach a cover letter asking USCIS to attach it, the I-130 to all the other forms, and we would mail in all the other forms with that cover letter and the I-130 receipt notice. And from that moment, now the work permit and green card are pending, and a few months later, we should have employment authorization and the Social Security card. So that's situation number 1. If you've filed Form I-130 and not any of the other forms, you should immediately file the other forms and attach it to that I-130. So now I would like to discuss the second type of situation I see where a permanent resident petitions for their spouse. In that situation, it is correct to file Form I-130 first, wait for it to get approved, and then file the remainder of the forms for the green card, the work permit, permission to travel, and all the additional documentation. The reason for that is because a visa is not immediately available for the spouse of a permanent resident. In fact, as of the date of the filming of this video in May 2018, USCIS is processing spouse petitions for permanent residents from May 2017. So literally a 2-year processing time until the I-130 provides an available visa number, and then we could file the remainder of the forms. Now this presents particular complications if that spouse immigrant is out of status in the US, because they won't be eligible for adjustment of status if they have unlawful presence. So that situation is only really a viable option if the immigrant spouse is here in a lawful status, like on H-1B visa, employment-based visas, or student visa, or extended tourist visas, they cannot have unlawful presence in that category, and that's a whole complicated issue and the subject of an entirely new video. So the point of that is that if you are a permanent resident petitioning for your spouse, it would be correct to first file Form I-130 and wait for it to be approved and for a visa to become available. Now, the third category I would like to discuss is where the immigrant spouse is abroad and we're going to consular process through the consulate in their home country. In that situation, the family member here who is petitioning for the immigrant abroad would always file Form I-130 first, wait for its approval, wait for a visa number to be generated and for it to be transferred to the consulate, and then step 2 would be to submit all the civil documents to the consulate and process them abroad. So those are the 3 main situations I see, but the key takeaway here is that if you're a US citizen petitioning for an immigrant spouse, I believe that in most situations it's a mistake to file Form I-130 without filing all the other forms simultaneously. And I understand that I covered a lot of information in this video and that it's highly complex and complicated, so I'm always available to assist you. If you have any questions, please send us an email at contact@darianlaw.com or give us a phone call at 914-885-3961. I've expedited this process such that from phone call to filing, we can have it all out and the process pending within 3 days, 72 hours if you're highly motivated. Although it typically takes us around 10 business days, we are able to expedite it and do it that quickly. So we have clients in most states and many countries who've never personally been in my office, and the way we do it is by video or telephone consultation. And then I email the signature pages to the client. They sign them and mail it back to me. It takes around 2 to 3 days to get to me. And during that time, they answer a questionnaire, which I'll prepare and email to them. With all of their answers and their signature pages, I now have everything I need to finalize the package and to mail it out to USCIS so that your status is pending and you can go on living your life without having to worry about any immigration issues. Again, my name is Pouyan Darian. I'm the principal here at Darian Immigration Law, and I'm happy to answer any questions which you may have. So give us a call or go on our website if you want to schedule a consultation. And I hope this video was very informational and that you gained a lot of value out of it. I wish you the best of luck in this process, and thank you for watching my video.